Hey everyone, my name is Cedric and welcome to Law of the Sea in a Seashell. Today we'll be exploring the 2011 advisory opinion delivered by the Seabed Disputes Chamber of the International Tribunal for the Law of the Sea, or ITLOS, titled Responsibilities and Obligations of States with Respect to Activities in the Area. Importantly, this case regards mining in the deep seabed, or the area beyond national jurisdiction, which is past the continental shelf. The development of mining there is governed by the International Seabed Authority, otherwise known as the ISA, and can be split into two general phases. The exploration phase, involving searching for and studying the minerals on the seabed, and the exploitation phase, where the minerals are actually mined. To exercise exploration, or exploitation, the ISA grants contracts to companies, otherwise known as contractors, that must be sponsored by states. This all falls under Part 11 of the United Nations Convention on the Law of the Sea, or UNCLOS, which governs the activities in the area. So, what triggered this case? Well, in 2010, two companies, Nauru Ocean Resources Incorporated, sponsored by Nauru, and Tonga Offshore Mining Limited, sponsored by Tonga, submitted applications to explore the seabed. However, uncertainties about state responsibilities in these contexts led to the International Seabed Authority to seek an advisory opinion. The questions that were asked were: what are the legal responsibilities of states sponsoring seabed activities? To what extent can states be held liable for contractor violations? And thirdly, what measures must states take to fulfill these obligations? Before we get to the answers of these questions, the Chamber had to determine whether it had the jurisdiction to respond. Interestingly, this case took place in the Special Seabed Disputes Chamber, specially created for issues related to Part 11 of UNCLOS, relating to activities in the area. According to Article 191 of UNCLOS, ITLOS has a unique advisory role when legal questions arise from the ISA's activities. Here, the ISA Council posed questions well within its powers concerning state obligations and governance of seabed exploration. Jurisdiction was therefore unanimously affirmed. Admissibility was also affirmed. Now, let's get into the substance of the advisory opinion, answering the three questions I mentioned earlier that were posed by the Council of the ISA. Regarding the responsibilities of sponsoring states, the court decided that they hold two major types of international legal obligations under UNCLOS for which they can be held responsible. Firstly, due diligence obligations, wherein states must ensure contractors comply with international seabed rules. Fulfilling the due diligence obligation means taking reasonably appropriate steps to creating and enforcing national laws, regulations, and administrative measures. Crucially, the standard of due diligence evolves. It depends on risks, activities, and technological advancements. Secondly, direct obligations. States have obligations independent of their contractors. These include assisting the ISA in its activities, applying the precautionary approach, adopting best environmental practices, and ensuring contractors conduct environmental impact assessments. Interestingly, the court mentions that special attention should be paid to developing states, as they should have equal access to the fruits of deep-sea mining. The second question posed to the court regarded state liability. Unlike state responsibility, which needs a breach of an international law, state liability has to do with damages that may occur even when there is no breach. In this case, what if a contractor causes harm despite the state oversight and regulation? The Chamber clarified that proving liability depends on two conditions: a state's failure to fulfill its responsibilities, such as the due diligence obligations, and actual damage resulting from this failure. If one does not exist without the other, the state does not incur liability. States can avoid liability by demonstrating they took, quote, all necessary and appropriate measures, unquote. In turn, this creates a strong incentive for states to maintain rigorous oversight. Finally, to meet these requirements set out in answering the first two questions, the court answered the third question. The court gave practical measures that states can take. Namely, it stated that states must adopt comprehensive laws. These laws should regulate contractor activities, ensure financial guarantees for environmental harm, and promote accountability. Moreover, they must be as strict or stricter than international standards. In essence, national measures can't be weaker than ISA regulations. Why should we care about this case? The ruling provides a blueprint for states navigating the complex responsibilities of sponsoring contractors. It makes clear that states need to regulate their activities in the deep seabed. As deep seabed mining becomes ever more relevant, this clarity strengthens global seabed governance. Also, it's a historic case. It's the first time that an advisory opinion has been made before ITLOS, and it's the first case before the Seabed Disputes Chamber. In conclusion, this is quite a great case, and as more states begin to submit exploration contracts and possibly soon even exploitation contracts, setting out the guidelines has become very important. Thanks for watching, and we hope you enjoyed this explanation of international law. Like, subscribe for more, and we'll see you in the next video. Ciao.